I had a question asking just sort of generally about the Endrew F Supreme Court ruling. What do we do about that? I mean, what effect has it had? What's the intended impact? And guys, prior to that, we relied upon what was called the Rowley decision, R-O-W-L-E-Y. Okay, the Rowley decision was the prior standard for defining what a free, appropriate public education was. Now, what was the scenario? Well, it was a child with a learning disability. It was a young girl that with a learning disability, and she's a general education identified student, and that was the case. And so, therefore, the sort of the definitions or the defining perspective of the Supreme Court, based upon the scenario in that specific case, tended to be geared more toward an academic perspective. Okay, and is that the fault of the Supreme Court? No. I'm not going to, they're humans. And so that was a perspective on that particular case to where they seized on the opportunity to help define what a free, appropriate public education was. Now, at the same time, the IDEA has not changed with regards to its mandate. And at the end of the day, when Congress created the IDEA, we have a mission statement in there. What is the purpose of all this funding? What are we moving towards? We're moving towards continuing education for all of our kids, starting at preschool, 3 years old to 21, all the way across. What are we trying to accomplish through this federal and state funding in order to assist our kids? Continuing education is a goal. Post-secondary education. Economic viability that they can provide for themselves. And then the third one is independent living. Those are the three mission statements for the IDEA. So you sit there and you take that. Well, the Rowley decision, it was more academic focused, but it didn't mean that the IDEA itself didn't have a sort of a catch-all for all students. We have, the IDEA hasn't changed with regards to its definition for special education. It's supposed to be specialized instruction geared toward a child's unique needs. So we need to differentiate our instructional approach based upon the child's unique needs. Okay? Well, unique needs is tied to their disability, right? Not their exceptionality, not what they qualified under, because their disability may not be the category that they qualified under. You need to make sure you understand that. Okay, so the unique needs aren't tied to the category that your child qualified for. That was just the thing that they needed to achieve in order to have an IEP and be recognized of being a child in need of specialized instruction. But Down syndrome, for example, they could qualify under a myriad of different exceptionalities. It doesn't mean that one exceptionality is the only area of consideration. Same thing with autism. The same thing with ADHD and OHI or any other disability. We are supposed to keep an eye open. That's just a mechanism through the door. But the consideration of the IEP team as to what the child requires is based upon the child's disability and how it manifests across the school setting and across their educational performance areas. And that's the most important thing, across their educational performance areas. Now, what are their educational performance areas? Their educational performance areas are academic, sure. But it's also social emotional learning, it's communication, it's independent and functional living skills. Okay? These four main areas. And then when your child gets closer to exiting and graduating, they throw in one more area, and that's transition. Transition into adulthood, transition skills that are needed. These are the areas, these four main ones, are the areas where we develop goals if the child displays deficits in those areas. But once again, the problem with Rowley is that it was so focused on academics, because that was a scenario that was brought before them, that the schools got into this habit of saying, well, we only deal with academics. We're an education agency. We're not a babysitting service. We're not a therapeutic center. We're not all these things. Yet they are. They are all those things. Because there's a book out there, about the hidden curriculum. The hidden curriculum involves good language skills and good social emotional development. Our schools are a breeding ground for that, or they used to be. They're supposed to. Now sort of they're breeding ground of sewage because of the stuff going on inside of our schools. That's another question I'm going to answer here shortly, because it's getting worse. But this is the thing. It's intended to be. I mean, look at Finland. Finland doesn't even really teach academics until the children are around 9 or 10, maybe a little bit later than that. Why? Because the science in child development tells us that we need good communication and social emotional foundations as structures for building academic learning, like reading and math. They need to be built upon the house, or the foundational structure. The house is built, as far as academics, on top of strong communication, social emotional development. And we're doing it the opposite in America. Absolute opposite, to where we keep shoving reading and math at lower and lower ages, instead of stopping it and focusing on strong language skills and strong social emotional skills. And then adding that later, okay? Back to that. So when Endrew F came along, it provided an opportunity because the scenario in Endrew F is that you had a more impacted child, autistic, far more impacted needs, disability impacting him across a myriad of different areas. And so the Supreme Court seized on that opportunity. And quite frankly, it was sort of amazing because the parents lost. They lost the due process. They lost on appeal. They lost at the appellate level. And then the Supreme Court took it, seized upon it. And then we got the Endrew F decision that came out of it that helped clarify what a FAPE is. Now, the Chief Justice Roberts wrote the decision. And what I like about it is he seized on that word unique needs. And he expanded that to include the child's individual circumstances. What are the individual circumstances of the child? Because the IEP team needs to consider that and then develop the goals toward the child's unique needs and individual circumstances. It's not just about academics, guys. And that's what Endrew F did, is it shook us out of, hey, it's not just about academics. We need to look at the whole child. We need to globally serve the child in the deficit areas for which they manifest inside the school setting. And you look at their educational performance areas, which is in the law, guys. We're supposed to build goals and services and equal access and accommodations for the child across those educational performance areas: academics, communication, social emotional development, independent functional living skills. Okay, 4 main ones. And there's kids with specific learning disability, dyslexia, to where they don't need things in these 2 areas. They may need it in communication and academics, but not in the other areas. But it doesn't mean that you don't consider it and you don't look at it as a possibility. Now, the question was, for Endrew F, what's wrong with the implementation? Why aren't we seeing such a drastic overhaul and change? Well, because it's board attorneys largely that train the schools. Okay, and the Supreme Court case is just a Supreme Court case. It's a way that the other federal courts can analyze what FAPE is. But at the same time, the law hasn't changed. The law didn't change after Rowley. The law's been the same. It was just an interpretation of what FAPE was. The law was still there as far as implementation and what you're supposed to do. Endrew F, same thing. The law didn't change. As far as the rules and construction of the IDEA, it didn't change it. It just changed the legal standard of analysis. But at the same time, that is a tedious, timely process because you need due process cases in order to then take it for an analysis on a due process level or a federal level. Well, that's not my goal. My goal isn't to sit there and take all my cases to an analysis on a federal level of whether or not a FAPE was provided. But that's supposed to be the analysis that the courts are supposed to use now. It's the Endrew F analysis. And we are seeing that happen. But at the same time, most of these cases get resolved through mediation or through settlement agreements or through resolution agreements. The mass majority of ours get settled that way. Now, at the same time, when we construct our due process complaints, we absolutely insert the Endrew F standard in there. And I go through the process of trying to teach my audience, whether it's a hearing officer or whether it's a special ed director or superintendent, whoever's reading it. I am inserting the new Endrew F analysis that, hey, you guys constructed this without considering the educational performance areas. I've got a kid in a self-contained environment and you guys only have math and reading goals. The kid's behavior is out of control. He's in a self-contained environment, but yet you don't have a behavior plan. You don't have social emotional goals. You don't have communication goals. The kid cannot button his shirt. You don't have independent functional living skills mixed in there. I point all those things out so that we can sit there and start moving the schools toward that implementation. But we also need to raise the level of understanding of parents. Do you understand the intent behind the Rowley decision and that it's expanded to look at all 4 of the educational performance areas so that we can develop goals and services in each one of those using the proper methodology of instruction geared toward your child's learning style, which is their unique needs, which is their individual circumstances. And this is where we loop in the right professionals, whether it's behavior analysts, whether it's psychologists, whether it is a very specific reading program where we need to train the staff in implementation of that program. It takes all those things. But the problem is that most of our schools are trained internally by themselves. They're also trained by board attorneys mostly, and board attorneys have a very singular perspective. They're not teaching and they're not retraining the schools on this Endrew F standard. They've been very resistant to do that because if they do that, then our kids would be getting more, guys, than they're getting, and we wouldn't be seeing a lot of this. And we have some great board attorneys out there. I'm not knocking, but that is where they're getting their information. It's slow going because of that. So it's our job as advocates, it's our job as parents to understand the standard ourselves so we can teach our IEP teams. And at that point, we can start making those changes within our own schools, which then ripple out. And then you pay that gift forward and impact other families by doing that.